Hello, my name is Destiny Grisby, and today we will be doing a presentation on Chapter 4, Police and Student Investigations, Searching Students' Bodies, Suspicionless Drug Testing, and Miranda Warnings. My group consisted of myself, Dylan Daniels, Michaela Price, and Jamia Johnson.
New Jersey versus TLO. It went down in March 1980 as a teacher caught two students smoking cigarettes in the bathroom. And as the students were taken to the office, their things were searched. And one girl, her things were searched. And not only did they find cigarettes, they found marijuana and, a list of people who she sold the marijuana to. And they called the police on her and everything. And TLO, she motioned to get the evidence thrown away because she said that it was against her rights for her belongings to be searched in the first place. And that motion was denied, and then she was later found guilty. And as they went to the New Jersey Supreme Court, they ruled that the search wasn't against the Fourth Amendment since they all had reasoning to go through her things. And the same way parents can go through their child's things in their room, an educator can go through a student's belongings if they have, a reason to. So.
Vernonia School District v. Acton. Vernonia High School in Oregon authorized random drug tests for athletes because they were concerned that drug use increased the risk of sports-related injuries. One student, James Acton, refused to take the drug test and wasn't allowed to participate on the football team. He said this decision violated his Fourth Amendment and that it was unlawful. Ultimately, the court decided with the school in a 6-3 decision, one of the reasons being that since student athletes are under state supervision during school hours, they are subject to greater control than over free adults. This decision concluded that it might justify individualized testing, but not random testing. Suspicionless searches, drug testing for extracurricular activities. Board of Education v. Earls. In 1999, at a high school in Tecumseh, Oklahoma, a high school official interrupted Lindsay Earls' first class of the day and told her to report to the gym's restroom for a drug test. Earlier that year, Tecumseh High School introduced a policy requiring any student who joined an extracurricular activity to submit to a urinalysis drug testing. Earls did not want to partake because she found it uncomfortable. She later filed a lawsuit saying that this violated her Fourth Amendment right. In a 5-4 decision, Justice Clarence Thomas wrote an opinion for the court in 2002 rejecting the claim that Tecumseh High School's policy violated the Fourth Amendment. This case was compared to Vernonia School District v. Acton. Thomas said that drug use amongst the youth had only gotten worse since that case. Earl, as well as the parents, were not pleased with this decision. David Earl said, "I am angry for parents and kids subjected to drug testing. As a parent, I had something taken away from me that I felt was a God-given right. I should be making the decision for my kids, not them."
The problem of strip searches. First off, Driver talks about Pierce versus the Society of Sisters. In 1922, Oregon modified its attendance statute requiring students between the ages of 8 and 16 be sent to public school districts where they lived. Two organizations operating private schools in the Oregon area, the Society of Sisters and the Hill Military Academy, challenged the constitutionality of the statute. Between March 16th and March 17th in 1925, the case appeared before the Supreme Court and held that two schools were entitled to protection against arbitrary, unreasonable, and unlawful interference with their patrons and the consequent destruction of their business and property. The court ruled that the statute violated the Due Process Clause. They also ruled that the Oregon statute unreasonably interfered with the liberty of parents and guardians to direct the upbringing and education of children. The court stated that the state could not force children to accept instruction from public teachers only. Next, Stafford Unified School District versus Reading. In 2003, an 8th grader, Savannah Reading, had to report to the school nurse's office at Stafford Middle School, where two female school employees performed a strip search. They did this because Reading was accused of giving 4 prescription strength ibuprofen tablets to another student. They didn't find anything. When they didn't find anything in her backpack, the principal told them to strip search her. She was stripped down to her undergarments and had to show some of her private areas. Redding did not contest because she felt that she wanted to do what she was told, but later filed a lawsuit against the school district and the school officials, saying that her Fourth Amendment right to be free of unreasonable search and seizure was violated. Her case was granted a summary judgment, and the Supreme Court agreed that her Fourth Amendment right were violated when the school officials searched her for underwear for the new pill. So, Driver also talked about a few other things other than the cases, but two issues that really surrounded the cases that he mentioned. The first of which is the school resource officers, which are officers that work with the school to enforce the code of conduct. Now, these officers are generally surrounded in controversy for a myriad of reasons. First off, in Clayton County, Georgia, when those officers were deployed, there was a sharp increase in referrals for high school students to the police for misdemeanors. In 1996, there was about 46 cases where students were were referred to the police. And by 2003, that number grew to well over 1,147 cases. So Driver really emphasized really questioned how effective school resources officers are there and whether or not they actually help promote a good educational environment. And one of the main tools that applied throughout the entire chapter was the searching standard. So reasonable suspicion versus probable cause. Reasonable suspicion is a standard that was created so then students could essentially be searched in schools to help create a better learning environment, quote unquote, while the probable cause standard is a standard that was created and is in the Constitution. So probable cause means that a reasonable person would believe that a crime was in the process of being committed, had been committed, or was going to be committed. Reasonable suspicion, however, says that the sort of common sense conclusion about human behavior upon which practical people are entitled to rely. Further, it has defined reasonable suspicion as requiring only something more than an unarticulated hunch. It requires fact or circumstance that gives rise to more than a bare imaginary or purely conjectural suspicion. As you can see, there's a lot of legalese between the two, and there isn't a very strong difference, but the reasonable suspicion standard is what students are under, and the probable cause standard is what people are under in the world generally. So what has happened is that students generally aren't trusted as much, and they can be subjected to search at a much higher rate without as much evidence being present. Thank you.
The last court case discussed in Chapter 4 was JDB versus North Carolina, the Fifth Amendment right to remain silent. This case took place in late September of 2005 in Chapel Hill, North Carolina. A school resource officer removed a 7th grade student from his social studies class to inform him that an investigator from the local PD wanted to speak to him. He was questioned for around 30 to 45 minutes, with questions geared to getting him confessed to breaking into 2 homes and stealing accessories from the homes. North Carolina sought to have JDB declared as a juvenile delinquent, but his public defender sought to suppress the confession. As it turns out, the local PD and school administrators did not ask JDB if he understood his right to remain silent. When the case went to the Supreme Court, the fundamental issue was, with a 7th grade student in JDB's shoes, he was pulled from class by a uniformed police officer, feel at liberty to terminate his exchange with 2 law enforcement officials and 2 school administrators by exiting the school conference room. In 2011, the Supreme Court issued an opinion announcing a 5-4 margin that a suspect's youth informs the determination of whether an individual is in custody for Miranda purposes. School was previously declared a Miranda-free zone, according to legal academics. Along with new age standards of Miranda rights, children had to be informed of their right to have a parental figure in the room, whether it was just their guardian or their actual parent. For children under 14, verbal statements, such as confessions, were inadmissible if no parental figure was in the room. During most questionings, they avoided giving Miranda rights because of the additional rights and protections that came with it. This court case, JDB v. North Carolina, does not guarantee that juveniles will receive Miranda warnings, even in similar situations. Um, the author's opinion, they stated that the court should have reorganized the Fifth Amendment right against self-incrimination to afford particular protections to students in school. The main argument was, regardless of age, students in the school system do not feel free to terminate police questioning, leading to them complying and eventually self-incriminating. So basically, they're saying that regardless of the age, whether it's a 13-year-old, 7-year-old, or an 18-year-old, when you're in a school setting, you don't feel comfortable walking out of the interrogation conference room. And so they're saying that that should have been taken into consideration, and the age should have been an additional protection after that. I know specifically in the JDB case, they had a rule in the policy stating that students were not allowed to walk away from adults unless the adult was finished talking to them. And so had the young man walked from the room, there would have been possible consequences, although that would have went to court as well. Though there could have been possible consequences, which can cause fright in students when it comes down to self-incrimination and talking. And that's the end of our presentation. Thank you.